Dear participants, as a member of the executive committee, it's an honor for me to moderate this seminar and to welcome you to this third seminar on Eli Mann's corpus, European Standards of Judicial Independence. This is the third one. Remember that the first one dealt with this core principle of judicial independence. The second one dealt with judicial governance, appointment, and promotion. And today, the third one is on ethical standards and judicial discipline. The Eli Mann's corpus, European Standard of Judicial Independence, was prepared by a group of experts, and it was adopted on 9 October 2024 and endorsed by the members the 27th November 2024 and published the 2nd of December same year. It is a way, standards are a way to control the attempt to increase efficiency and transparency, to make sure that that attempts do not violate the core principle of independence of justice. And it's particularly important in our time where the state of law is in risk and where the technology and in particular the artificial intelligence may be a way to replace the judicial decision. Today, we are going to see the articulation between the ethic which is imposed to the judge when he make a decision. In French, we say rendre justice. Rendre, it's a way to give back justice to people. He has a responsibility for that, and he's accountable for that. But the independence of the judge and of the justice has to be guaranteed by security of tenure and irremovability. So today, I would like to take the opportunity to congratulate all the members, the 4 co-reporters who prepared these standards, Professor Shiman Shistrit, Professor Sophie Turenne of the University of UK, and Professor Leah Worthman, who is present today, and Professor Friedrich Zoll, Professor Leah Worthman from the United States, and Friedrich from Poland and Germany. The 4 reporters make all their effort to prepare this report, and the report was then enriched by diverse groups of experts and by the advisory committee of Eli, by the membership consultative committee of Eli, the council members, and all Eli members at the annual conference. I also must take the opportunity to thank Professor Christian van der Horst. She's Eli's scientific director, and she's very much behind all our project. So we are proud to share the result of this work, and we will share with you. And we have today a panel composed by 2 reporters and people who will react on this result. Before starting, I would encourage you to use the Q&A functionality to ask questions. You cannot use the chat, but you can use this function, and that would be a way after the presentation to ask questions. So we are going to start with the presentation of this part of the standards, the paragraph 30 to 37 of the standards. And this is Leah Wossam, who is going to make the presentation, and Frédéric Zoll will add some comments to this presentation. Leah Wossam, she's a professor at the California University of America in Washington, D.C. She taught legal ethics, and she chaired the District of Columbia Bar Rules of Professional Conduct Committee, and she's worked in particular on legal ethics, legal profession, legal education issues in many countries, in particular in Poland. So, Leah, I'm going to give you the floor for this presentation.
Thank you so much. My university needs to say I'm the Catholic University of America in Washington, D.C. I want to begin. I'm sure many of our webinar guests have been with us for the previous two and are familiar with the standards overall. I will very briefly mention some overall premises and approaches of the project, which distinguish it in some ways and are similar in other ways to other standards of judicial independence. First, of course, judicial independence is vital to the rule of law, democracy, and human rights, something probably that becomes more apparent every day. Judicial independence, of course, exists to protect those values, which require most fundamentally public trust in the judiciary. Judicial independence is not a personal privilege of judges. We were fortunate that Shimon Shatrid, our fellow co-reporter, has spent much of his career developing the notion of a culture of judicial independence. It's not just about formal law. Of the standards, we talk about the interaction of provisions affecting the judiciary as applied, not just the formal system, looking at the action of actors involved and considering how the system appears to the public regarding building their public trust. This project in particular focuses on European standards, including career judiciaries. When one looks at some other standards, they often are very strongly common law influenced, and there are ways in which they were difficult to adapt to career judiciaries. Frédéric and I had written extensively about the Polish experience from 2016 to 2021, which somewhat laid out a roadmap of ways to attack judicial discipline, and particularly a way to attack judicial independence, and in particular weaponized judicial independence, which is reflected in part in seeking to find some antidotes and tripwires to that within the part we're discussing today. So our approach was to be very explicit about statements of objectives. We throughout try to recognize differences in systems. There are alternative paths that can be fine. The question is the outcome of an action within a system going to be consistent with the objectives of judicial independence standards or not? We seek to set some tripwires, some guardrails that can't be crossed. As mentioned, introduction, of course, irremovability, as you well know. Seeking to lower the retirement age of Polish judges was something where the CJEU very much set a very important bright line that was a big turning point in the events in Poland. So we wanted to give a reference tool with checklists and that could be used very practically on the ground. Again, we do recognize in variations and that there may be differences with respect to a country's particular history, cultural, political environment, something that is a guideline that just no one crosses in a particular country, given its history, needs often to be stated explicitly and could be problematically implemented in another. We recognize well the debate among decision makers about judicial oversight and governance, whether processes need to be totally controlled by judges, as opposed to the notion that a more mixed body with a majority of judges usually is the outcome, but with a strong voice for representatives of other legal professions, academia, civil society, other stakeholders who have an interest in the judicial system. One feature of these standards was that while many distinguished judges were involved, the process also brought in bar members, academics, international organizations concerned with human rights and democracy. We had, in addition to our advisory groups, who were very helpful, we had comments from more than 60 individuals or representatives, not only of judicial organization, but from other points of view. And all of those were considered and taken seriously and did involve some of the final effort. So I now move specifically to the parts we're talking about today. We attempt to make a very strong distinction in ethical standards for guidance, the general principles that judges are to look to themselves on questions like when to recuse themselves, some questions of day-to-day conduct, the things they say, the events they go to, as opposed to conduct that crosses a line to discipline. Now, of course, there's an overlap. There are things that are ethical standards that, when violated and happen in a particular situation, are also disciplinable offenses. But in my experience of looking at this in many countries of the world, sometimes it has been overly blurred. And we try to make a very sharp distinction between the important function of a judicial ethical code, preferably with a group of people to interpret that code and give guidance when judges have questions. But particularly, that's something judges are expected to look to themselves for the notion of how they guide their conduct on a day-to-day basis. We come out on the side that general statements, what's dignified, are appropriate standards in ethical guidance, but they do not have the specificity that should entail discipline. I have long been an expert in lawyer discipline, and there's certainly, at least within the United States, been a strong move to more and more of the protections of the criminal system, including specificity of offenses. And if one looks at the evolution of the Venice Commission, of the ODIHR, the opinions, there has certainly been a move toward more specificity in judicial offenses definition. And we come out very much on the side of that. It's important to know what is permitted and forbidden, but it's also important to limit the room for discretion exercise when it's done so to exert improper pressure and transparency for the public. That was definitely an issue in Poland in terms of having very broad, malleable standards weaponized to go after judges. What's perhaps particularly timely is about ethical considerations, including judicial freedom of speech. Judges have rights as citizens within the constraints of retaining legitimacy as an independent and impartial. We go on to say, though, echoing opinion of the CCJE and other important bodies, that when there is a threat to the functioning of the justice system, judges may have a duty to speak, which is just beyond their right as a citizen. Other topics about a process for judges getting ethical guidance can provide guidance as well. Then specifically about the disciplinary process, we talk about the importance of the accountability and public legitimacy as requiring a process for complaints. We have a very broad statement that courts should have a place where complaints can be made and that anyone can make a complaint. That is not, those won't all be specific to judges, but I think it's, for us, it sort of made sense that there's a central place that retains complaints. There then, though, has to be, and here again, we relied on CCJE opinion and some other sources on the notion that then you have to have an effective, legitimate, and fair way to screen those complaints. Because many of those complaints, of course, will not be ones that, even if there was evidence, constitute a complaint. As we say in American civil procedure, failure to state a claim. And it's important that there is a way that those are assessed, and those that do not state a claim or for which there seems to be no credible evidence can be dismissed. And so that screening mechanism is very important. Then we go on to say strongly that judicial discipline should never be about the content of a judicial decision. The way of resolving bad decision is through the country's appeal process. Earlier when I was talking about complaints, that there must be a separation, absolute separation between the people, the entity who initiate, receive, and review a complaint and make a preliminary investigation to see if there is something to go forward versus the hearing and deciding. Those should never be the same people. And normally, at least half of the members of the disciplinary body or bodies that investigate, hear, and initially adjudicate the complaint must be judges. Normally, again, I discussed earlier the arguments in both sides about lay members, which groups should be involved. I was part of the excellent discussion, at least, of the revision of the Kyiv standards through ODAHR. And they did some excellent work on the complexity of defining civil society representatives. What does that mean? There are certain groups, like perhaps a bar association, that have an elective process. So it's easier, at least a sense, to think of who's a legitimate group, who's a legitimate representative. But it's an important, on the one hand, to have lay representation, but it's a complex question to define who that would be and how to do it. And we say this is one of the places where we just say that a state's history and culture can be a factor. Very important to keep the investigation to the scope of the complaint. This was one of the abuses in Poland, making opening a complaint being a fishing expedition that could go into suddenly all sorts of other things. We talk about fair trial requirements that really very much approach protections of the criminal process. That includes the length of the proceeding, that it's speedy enough that it doesn't go on forever, but that it also gives judges adequate time. And we talk about equity of arms. There's a number of specificities about the fair trial process. I've already discussed specificity in defining offenses, a proportionality requirement, and finally, distinguishing the disciplinary process as opposed to incapacity. That those are two different things. The same fair trial standards likely apply, but someone who is thought to be incapacitated from mental or physical illness is a quite different question from the statement about a discipline process. We also say that the same standards of fairness, by and large, would apply in an impeachment system, even though that's, of course, very different from a disciplinary process. I think Frederik's going to make a couple comments.
Thank you, Leah. And yeah, Frédéric, I'm going to give you the floor after having said that you're well known in Eli's world. You're a professor in Krakow in the University Jagiellonian. And you were made Dr. Honoris Causa and member of the supervisory board of the West Ukrainian National University of Ternopil. And I think you've been since 2024 a member of the Polish Codification Committee for Civil Law. So could you perhaps add some comments to what Leah just said?
And I also professor at the University of Osnabrück, which is my second place. The main idea, of course, as we have discussed, there is certain Polish background of his rules, but of course we were trying very hard to not to be focused on very particular experience of one country. In our discussion, we were trying to see the process of changing of disciplinary procedure and its function. Because at the beginning, the disciplinary procedures and disciplinary system of disciplinary responsibility or liability was a part of kind of self-purification model of certain professional group, which was and therefore for certain reasons the standards were quite different from criminal law standards. We were trying to, but it must be much more flexible system because it is kind of closed club internal model of self-purification. But this model has been changed. This model was, the expectation was different for a long time. In certain model that the criminal law or other system of responsibility do not fulfill the function of efficient sanctioning, and this internal self-purification system for many reasons didn't work. And we had a process of trying to somehow to circumvent certain requirements of criminal law by disciplinary procedure, or to, in such situation as in Poland, where the separation of power was under question, how to try to avoid or circumvent the independence of judges. In our framework, we were trying to make a model which tries to describe basic guarantees for substantive disciplinary law and for procedure. And you can find it is, of course, in certain senses, a simplified model. We are not providing a set of rules. We are not providing a model which can be just implemented in countries as a model of disciplinary responsibility. But what we have, it's just a framework to assess the models, to prevent an attempt to weaponize a system of disciplinary procedure against the judges, to undermine their independence. And this is quite interesting exercise also in Poland, where the political situation was changed. And then is the question in the new circumstances also that these standards are very important. But we can, there is always a kind of incentive for every kind of power to use weaknesses of disciplinary procedure to make the independence of judges relative, mostly in the situation where the judges do not want to observe certain policies of the country which undermine the independence of judiciary. Nevertheless, of course, the system must be sufficiently flexible. It is not a criminal law, but certain standards of criminal law must be more stressed as it was. Our text is not a restatement of law. You can find judgments of the Court of Human Rights which would say something different, as we are stressing, in certain sense that disciplinary procedure is not a criminal kind of criminal responsibility. We were trying to say that certain principles of criminal law, certainty of delicts, which are a basis for liability, due process, and prohibition of retroactiveness, a kind of avoidance of using a very general clauses, judicial dignity, as sufficient clause for starting the disciplinary responsibility or disciplinary procedure, that it is not enough, that it must be much more precise, that exactly the misconducts must be provided by law and sanctioned in the proportional way. And we were trying also to close a little bit the way to circumvent the system. So this is a model which tries to put a disciplinary procedure in this modern function as an efficient system of sanctioning misbehaviors of judges, but not providing a tool for executive power or our powers of the country to undermine the judicial independence and to force judges to follow certain political agenda which is not in line with the separation of power. And this experience, this model was based on this experience. Thank you so much.
Thank you very much, Frédéric. So you just mentioned that it's not a set of rules, but it's rather a framework to assess a model. And I'm going to give the floor to Thea Yaliashvili. Thea, you are in the OSCE Office for Democratic Institutions and Human Rights, first Deputy Director, and you have a great experience in cooperation programs in the field of human rights, democracy, rule of law. And I also noticed that you also served as a deputy director at the Women's Information Center in Georgia. Thea, you worked also and you know this Office of Democratic Institutions of Human Rights give recommendations, and it's interesting to have your point of view on or on the ELI standards, on the method which is used, but also on the substantive result. So, Thea, you have the floor.
Thank you. Thank you very much. It's indeed a pleasure to address you today at this very important webinar organized by the European Law Institute. Definitely at ODIHR, we focus on implementing our mandate in human dimension, with the rule of law and democratic governance being an important part of it. And as we work towards supporting participating states, 57 participating states, in strengthening the rule of law, of course, it's fair to say that judicial independence and accountability are those main pillars for the effective judiciary, as well as the foundation for a very well-functioning democratic governance and strong protection of human rights. When the judiciary is both independent and accountable, definitely we all would agree that it will enjoy public trust and ensure fair and effective administration of justice. Today, of course, I'm delighted to have an opportunity to discuss the intersection of the European Law Institute Mountain Scopus European Standards of Judicial Independence and our work in promoting judicial independence and accountability across the OSCE region. And in my presentation, I really would like to explore how those standards, particularly your standard, those on ethical standards and judicial discipline, align with and also complement to our two flagship tools in the field, such as Warsaw and Kiev recommendations, two key instruments reflecting our commitment to support judicial independence and accountability. In terms of the context, allow me to let you know that we have published those key recommendations on judicial independence in Eastern Europe, South Caucasus, and the Central Asia, which had a primary focus on the specific needs and realities on the grounds and emphasize for the need to robust institutional safeguards against any kind of political manipulation or the lack of adequate resources to support the judicial functioning. And of course, very important part, which is the meaningful civil society involvement in judicial reforms. And following those developments in the region, we further developed those recommendations on judicial independence and accountability, so-called Warsaw recommendations, to address the emerging threats and challenges to the judicial impartiality and integrity, regretfully throughout the whole OSCE region, which we have published in 2023. And of course, these documents draws on those decades of our experience and engagement in monitoring and advising judicial systems, offering guidance tailored to the unique needs of participating states, and of course, while building on those key recommendations. At its core, the Warsaw recommendation underscored the importance of independent judicial councils, clear ethical frameworks, and the proportionate disciplinary mechanism to protect the judges from any undue political interference, while ensuring, of course, accountability for any misconduct. Together with the Warsaw and Kiev recommendations that reflects our commitment to adopting the international standards to the regional and national context, and as you rightly mentioned, it becomes a kind of like a regional standard to look into when we're talking about those developments. Now, how is this intersection between the European Law Institute Scopus standards and Warsaw and Kiev recommendations? Of course, we both work together in establishing standards for independent judiciary, primarily focusing mainly on ethical standards and judicial disciplines. Standards from 3037 of the LE-MT Scopus standards complement to those of ours by addressing these two critical issues. And very, very briefly, these are the three shared priorities. Ethical standards. All three instruments emphasize the need for clear and enforceable codes of conduct that guides judicial behavior without undermining judicial independence. Standard 3031 resonates with our recommendations as a call for transparent ethical frameworks that inspire public confidence and protect the judges from undue pressure, and both stress the ethical guidelines should empower judges to make decisions with integrity while definitely ensuring accountability for violations of those guidelines. The second is judicial discipline. Proportionality, transparency, and fairness are the cornerstones of those disciplinary mechanisms as highlighted in standards 3237 of the European Law Institute Scopus standards and both the Warsaw and Kiev recommendations. And of course, these documents converge on the principle that disciplinary procedures must not be used as a tool for the political retribution. Instead, they should serve to uphold the integrity of the judiciary by addressing misconduct in a way that respects the due process and judicial independence. And last but not least, judicial councils. Independent judicial councils are pivotal in safeguarding both judicial appointment and disciplinary proceedings, and the Warsaw recommendations emphasize on independent judicial councils aligns closely with the LE Scopus standards, focus on ensuring that such bodies operate free from political influence. The Kiev recommendations further elaborate on how judicial councils can address region-specific challenges such as political interference and insufficient institutional resources. While European Law Institute standards provide a universal framework for ethical standards and judicial discipline, our Warsaw and Kiev recommendations offer also context-specific guidance. For example, under the Warsaw recommendations, we also address the modern challenges like digital threats to judicial independence and the need for the innovative solution, as for example, the online platforms. The Kiev recommendations provides a roadmap for those countries who are grappling with the systemic challenges, such as entrenched corruption and the political influence, one again and again over judicial appointments. And the integration of European Law Institute standards with the Warsaw and Kiev recommendations, I think, represents a unified vision for justice. Ethical standards and judicial discipline are not standalone elements, and of course, they are interconnected pillars that strengthens the judicial's credibility and the resilience. And definitely by adhering to those shared principles, we can support states in developing their judicial systems that command public trust and uphold the rule of law. Another issue that I would like to very, very briefly touch upon is the contribution to the judicial independence and accountability. In our case at ODIHR, we of course operationalizing those principles, and there are few other examples other than our Warsaw and Kiev recommendation. Legislative support, where we are assessing lawmaking procedures and practices to promote adherence to democratic principles and the rule of law and the compliance with the international human rights obligations and standards, improving the legislative processes, and also working to providing participating states with the legal opinions on legislation, in particular pertaining to the judicial independence, accountability, appointment of judges, and other judicial-related topics. Another important tool at our disposal is under the monitoring and reporting. It's our trial monitoring programs that assess the judicial system's adherence to fairness and independence. And we are also monitoring the vetting processes in participating states, and the reports usually provided very tailored recommendations to enhance procedural safeguards for the fair trials and ensuring judicial independence. Capacity building is another important tool, like a training programs for the members of judiciary and supporting judges in their work. For example, now we work with the Ukrainian Supreme Court, inter alia, in developing the practical guidelines for adjudication in war crimes. And this work is designed to provide judges with hands-on manual supporting drafting of verdicts in case of international crimes. And last but not least, of course, the primary and one of the very important tools is the fostering dialogue. And we could facilitate the platforms among judges, policymakers, and civil society. In closing, I would like to emphasize that our unwavering commitment to supporting judicial independence and accountability in the OSCE regions, and we are very well aware of a huge amount of challenges across the participating states, but also believe that through the frameworks as provided by the European Law Institute and the Scopus standards and our Warsaw and Kiev recommendation, we really have the tools to support the states. And I would like really to thank you for giving the opportunity to talk about these very important issues, and of course, look forward to engaging with you during our discussions, but also with the wider communities, to discussing those pressing and important challenges that we are facing at this moment in time. Thank you very much for your attention.
Thank you very much, Thea, for all what you said, and for it's nice to see that there is same objective of public confidence and protection of judges. I'm going to leave for the debate the question you arose on specific guidance and education in particular, and I'm going to give the floor to Georg Kodek. Georg Kodek, who is president of the Supreme Court of Austria, who has a career as a judge, who studied in Chicago too, and who is at the same time an academic because he's a professor in civil and commercial law in the Vienna University of Economics and Business. I think it's interesting to have also the point of view of a judge. So as a judge, how do you receive that's standards, but also how do you receive them as the president of a Supreme Court, because the Supreme Courts have a specific function in the states, and how do you also react as a member of the network of president of Supreme Court, which is a way to create the strengths of the body of judges in the European Union. So, Georg Kodek, I give you the floor.
Thank you. Good afternoon. Thank you very much for inviting me to speak at this occasion, and thanks to the drafters of this document. I know from personal experience how difficult it is and how time-consuming to put together something like this. Many years ago, I took part in a conference chaired by Professor Siegfried when a much earlier version of the current document was discussed. I have to admit I'm somewhat skeptical about the added value of such a document, because perhaps it tries to achieve too much. It is at the same time, in my view, overly broad and too specific. Now, this is not a contradiction. It may be in parts overly broad, because it goes, and it does so intentionally, of course, it goes beyond what is normally understood as independence. It touches upon issues such as quality of justice, the duration of proceedings, but even matters such as technology, and briefly mentions AI also. It deals at quite some length with impartiality. And this broad effort leads to the document being perhaps necessarily being somewhat vague in parts, and therefore it can provide little guidance. The principles as such, in my view, are sound. but I would not subscribe to what is said in the preface of the document, that all principles are commonly found in the constitutions and case law of democratic countries. When we talk about judicial self-governance, you may know many European countries have a Ministry of Justice, which takes part of the administration of office space and so forth. Also, I do not share the pessimistic attitude expressed again in the preface of the document that the independence of judges around the world has been under increasing threats from governments. Now, clearly there are threats, there are dangers, but overall, I think I would be more optimistic. My generation has seen the fall of the Iron Curtain. Of course, earlier we had seen, fortunately, the fall of fascism. There are still threats, but overall, when we look at the world as a whole, I think things are getting better. One last general comment before I turn to some specific observations. Judges should be independent, of course. They should be impartial. That is what the document talks a lot about, but they should also be diligent, they should be courteous, they should be well read, well versed in the law they apply, and so forth. So one of the dangers of having such a comprehensive document is it may create the impression, even though if it's not intended, it may create the impression of being an all-encompassing document, an exhaustive document, and then people but may infer that what is not in the document is not required or is not desirable. Clearly, that is not intended, and it should not be read this way. Now, let me turn now to some specific observations. Standards 30 and the following standards deal with ethical standards. I'm not convinced that there should be drawn a distinction between ethical and legal standards. In my view, and that is certainly the position of other German-speaking countries also, what you describe as ethical standards are legal standards. Not every violation of a legal standard gives rise to disciplinary sanctions. It's quite clear. A simple example, the judge starts a hearing 5 minutes late. That if there is no cause for it, that is a violation of his duties, but clearly a very minor violation which should not, and I think nowhere does, trigger disciplinary measures. Also, I'm not sure that it is possible or even desirable to draw up more specific standards. I understand why some countries would want that, because clearly disciplinary standards have been abused, but it's very difficult to put that in concise language, which is sufficiently clear on the one hand and sufficiently complete on the other hand. Standard 32 deals with the freedom of expression, and I think that is one of the most difficult parts, because judges not also are to expect the rights of others, but also are holders of constitutional rights themselves, and that is where we have to strike a balance. Now, a one-word answer to that problem is judicial self-restraint. But the question is, of course, how do you apply that in practice? Just a few examples from my own experience. We had disciplinary proceedings where judges spoke quite freely on Twitter, which is now called X, expressing political views about political parties, not related to their cases, but still undermining the impression the public gets, because the public might think the judges have preconceived politically party-driven notions and when approaching cases and so forth. We had a case where a judge uttered and posted political, not only political views, but views about a defendant's guilt in a criminal proceeding, which was chaired by that judge's spouse. And that was difficult because clearly the judge cannot be blamed for her spouse, but we have to blame the judge that puts the entire trial and his spouse in such a situation. And we just recently we had a proceeding where the president of an intermediate appellate court hung out a rainbow flag on his court, and that was criticized in an email by another judge of his court. Now, that email used language which the judge called satirical, which was at least on the borderline of homophobic. But how do we treat judges as holders of constitutional rights? So that is very tricky. And now turning to my own role, which you described as kind of professional hybrid, being both a sitting judge and an academic, albeit with a greatly reduced teaching load. The document says, the comments say one should not talk about one's own cases. Now, that is 100% true when the case is still pending. I would not agree once the case has been decided. All that matters is what is said and how it is said. American judges talk about, Supreme Court judges talk about their cases all the time. Well, they should make clear they are not revealing confidential information. They are not revealing what was discussed during deliberations, but they may direct the audience to certain parts of the decision, certain paragraphs that may have been overlooked in the debate, may highlight open questions that have not been decided, that may come up in the future, and so forth. So again, judicial restraint, tact, common sense is the answer here. Now, when we turn to disciplinary proceedings now, I think it's very difficult, and indeed, in many countries, it's not done, to write up, like in a penal code, what are possible violations of duties. Many countries have what I would call an elephant approach. I cannot describe what an elephant, I cannot define what an elephant is, but I recognize it when I see it. A few months ago, I chaired a disciplinary proceeding against a judge who had urinated, who had peed in front of his courthouse in the public. Now, there is no part in the Austrian law, and probably not neither in many other countries, which prohibits a judge from peeing in front of the courthouse, although we all will agree, I'm sure, that this is highly improper conduct. And we were not talking about medical emergencies and so forth. So I think that's very difficult. And indeed, many, at least Central European countries and certainly German-speaking countries have an approach where any violation of professional duties can give rise to disciplinary proceedings. Maybe one specific point, it was highlighted earlier today that the contents of the decision should not give rise to disciplinary proceedings. Judicial error should be addressed in the course of appellate proceedings. I would agree, but I would not agree 100%. There are gross errors which can only be explained by a lack of by a gross violation of standards of care. And if such mistakes occur repeatedly, such as keeping people in prison too long because it was overlooked that after maybe 2 weeks, there has to be a renewed decision about pretrial custody and so forth, that could be raised in a disciplinary proceeding. And occasionally, fortunately, very occasionally, it is raised. One difficulty the document does not mention is the difficult situation of having hierarchical structures within courts. Within panels even, when the presiding judge is someone appointed to that position and maybe also in charge of evaluating, of describing the other members of the panel, and that may be an important part in their career, their advancement. Again, this has to be handled with tact and common sense, but it is potentially dangerous. Now, ultimately, because I only have a few minutes, I would like to end with a more general observation. What really matters, and that cannot be or hardly be prescribed in a document, is the overall legal culture. So how is judicial independence practiced? How is it lived in a certain society? So how operate the rules, how operates the system in practice? So the law in action is what matters here. For example, in the United Kingdom, the king, upon a motion from Parliament, can remove a judge, but it's never done. So practice is what's matter. But what is also important, of course, is to create awareness in countries which do not have a century-long tradition of judicial independence and the rule of law. And perhaps in creating such an awareness, or in contributing to the creation of such an awareness, a document like the present one is valuable after all, in spite of the criticism I stated beforehand. Thank you.
Sorry. Thank you very much. And I'm going to leave for the debate all your reactions, which are so interesting on various issues. And I'm going to give the floor, because we are not very much in time. I'm going to give the floor now to Timur Shakirov. And so you are deputy of Europe and Central Asia program, and you have a great experience of Central Asia, and it's interesting to have your reaction on this document, which is mainly based on the decision made by the Court of Justice of the European Union and also of the European Court of Human Rights, with the purpose of dissemination outside Europe too. So it's interesting to have your reaction on this paper. So I give you the floor.
Thank you very much, dear colleagues. It's a pleasure to be here at this meeting and to discuss these issues. As was introduced by Chair, I'm acting director for Europe and Central Asia project. So we're programs of the International Commission of Jurists. So we work on the judiciaries in Europe, in Eastern Europe, Western Europe, and Central Asia. So basically covering more or less the OSCE region. And of course, as an organization, but the International Commission of Jurists, ICJ, to be short, the other ICJ or another probably, we very often come across cases of attacks on lawyers and judges, and in principle, the commission consists of judges and lawyers in different countries of the world, covering every region. And we are, I'm speaking to you from Geneva. We have the headquarters in Geneva, where from where we look into different regions, but also we have other regions in other parts of the world. In my very brief remarks, I'll come from a bit of a different perspective, from the perspective of an organization that comes across cases where pressure is put on judges, where political pressure is put on judges, or the judiciary, and where the judiciary comes very often under attack, and it's done through the it's never done through some bad intentions that are declared. Very often it's the reform, improvement, tackling corruption, or other good intentions. But in reality, what happens often is that other branches of the government or of the state, in particular, often the executive, that is trying to impose control over the judiciary in this in different ways, institutionally, by creating a chilling effect on judges, or by interfering with various procedures on appointment, career, or disciplinary system against judges. From this perspective, I find these principles to be rather helpful. We intervene before the European Court of Human Rights on a regular basis. We intervene in cases on Poland, on Hungary, on Turkey, and we see rather problematic developments not only in these well-known states. When you speak to judges in Malta, or lawyers and judges in Malta, or in Portugal, or in Spain, you see currently there's another issue in relation to ICC in Italy. You can see how often the obvious principles, which may sound very obvious, too obvious, come under attack, not in countries which are well known for their non-democratic history, but in rather established democracies, including the EU, where quite a lot of pressure may be put on the judiciary currently. And we can see that, or we can observe that there may be waves, but currently the wave is not in favor of institutional independence very often, and this is quite unfortunate. We can see that a highly developed in the recent times, in the recent years, how well developed became the jurisprudence of the European Court of Human Rights in regard to judicial independence, and the cases are only from 10 years ago, and that can be observed. Now, it's good that these cases have been, and many of these cases, by the way, are mentioned in the standards, which is really good. I find, apart from the standards themselves, I find a very useful, this addendum. I think it's maybe whoever cares enough or reads to the end will appreciate also that part of this comprehensive document. I think I'll just make a few specific remarks because there's a lot to say about the standards themselves and the explanation, the commentary. But I'll just probably from my point of view, from our point of view, looking at these cases in Europe and, as was said, outside of Europe, not just in Central Asia, but Africa, in Asia, and Americas, where we observe various trends. But again, in Europe and the EU space, in particular, it's quite fortunate that at the core of the ethical, moving to the ethical part of the standards 30, 32, that the judicial independence is put at the core of judicial ethics. And again, the standard may be a bit too obvious and known to lawyers and non-lawyers, judges, non-judges, but in fact, we see that often in the recent cases, it's the judicial independence on which judges speak about, and then they may be disciplined or face other sanctions. A very famous Baca case, or so many cases, they actually hit at this core, and where judges are seen as those who breach judicial ethics by speaking about these issues, a problematic reform or attack on the judiciary. And this is where it's so important to remind in a new document that at the center of judicial ethics is judicial independence as the core value. Then I think it's so important that the principles speak about fostering a culture of judicial independence. We've never, it's in the same standard 30, but we've never reached the end of history in judicial independence. I think this has to be appreciated, that it's always work in progress. You always have to be vigilant. As soon as you think that's done, you lose the vigilance, and it may start eroding. The judicial independence may start eroding. So it's so important to speak about the culture of the fostering of culture of judicial independence, impartiality, and integrity. Now, of course, it's obvious that it should be judges that set standards, but in Volkov, for example, it was the parliament basically who was deciding. It was in Ukraine case, and quite a well-known older case, but it's also must not necessarily be an obvious principle. It's a well established judicial international standard on the independence of the judiciary, and European standard that judicial ethics and disciplinary measures should be separated. And it's not always the case. Again, and there have been cases where this principle has not been followed. Balancing judicial discretion, judicial constraint, and freedom of expression is probably, I agree, this is probably one of the most difficult ones. How do you balance freedom of expression of a judge as a citizen, as a judge's human rights, and then the judicial function? And I think where the Scopus principles are very helpful, they're explaining or they're stressing that it is sometimes the duty of a judge to stand up for independence. So, and in cases, we see these cases before the European Court, but those who haven't reached the European Court also in various fora that we convene, we hear that it is this exact problem that when judges start speaking out, the disciplinary cases often are initiated on the freedom of expression, on the right to freedom of expression. So the fact that it is framed as a duty of a judge is quite fortunate. I think the drafters spotted the problem very correctly. Now, maybe moving on to and also the beauty, that's another one. The duty to speak outweighs it. It says so. It's on the same matter, but the duty to speak outweighs the duty of restraint when democracy is under threat. I think, again, from the perspective of an organization that comes across so many cases of attacks or political attacks on the judiciary, this I have to say, this is rather fortunate. Judicial discipline principles 33 to 37. I understand we are running short of time. We have run short of time, so I'll try to be very quick on this. Just probably to say that judicial disciplinary system is a double-edged sword, and you either can improve the system or harm the system. This is actually how you make sure that judges either administer justice, or they follow or you cleanse you rid the system of those who are independent, who think independently. And it's probably this the greatest pressure point that will and does create the rippling effect, the chilling effect against the judiciary, or actually helps improve it and make sure that that the system is rid of corruption, that it's cleansed. So I think either this and that's why these standards, including fair trial, the need to have to be able to appeal against it to the regular judiciary. We may be surprised how often these cases occur. They actually are. These are reoccurring cases, including in the European states, and we can look at the jurisprudence of the European Court of Human Rights and European Court of Justice. We can actually see all these cases, and in Poland, for example, we see that there's an improvement, but still the echo of those, it still hasn't been fixed completely, unfortunately. So I think I will stop here, and maybe there'll be just because we're running out of time, but maybe there'll be a possibility of addressing some of the questions. Thank you very much.
Thank you very much, and sorry because I was quick to introduce you. So we were a bit late, and it's clear that this international commission focuses on all these issues we speak about today. So now it's time for the question, but before going to the question made by the participant, I would like to give the floor to the two co-reporters, because they probably have some reaction to what was said by our participants today. So I don't know whether Leah or
Frederic, please first.
Okay.
Thank you so much. Thank you very much for this very interesting comments on this model law. And of course, Justice Professor Kodak is completely right that we had always this challenge with Germanic countries, which they have specific system where certain guarantees are organized in quite specific manner, which is not so easy to transfer to another environment, and the specificity still is working well, despite certain threat also to the system. I think the function of all our principles is a little bit also a warning to look critically on the different system in Europe, even they are well working now. But we are, I think, now in Europe under very complex political pressure. And this political pressure could be a threat also for democratic systems, could be a threat for separation of power. And of course, such principles are not able to prevent all risks. But I think there is a time yet to very critical look on systems. Of course, we are trying also in our principles to consider that somehow the intention of certain rulers matters. In this way that sometimes solutions in one country which are working perfectly well because there are other safeguards to the system, which are on completely different levels, so to say, work. But we have also to look that this intention can be changed if the system is not sufficiently weaponized against the threat in abolishing or infringing the separation of power. Of course, this being a little bit too broad. I think the idea of these principles is also to show very, very clearly that independence of judiciary is not a value in itself. It is a part of a system which must be seen with all other components of efficiency of judiciary, of other elements, which makes the guarantee for well working rule of law in a country. And of course, also the independence of judiciary can be abused under certain circumstances. So we were trying, I think, to show all these principles, how to find a balance between the independence of judiciary and efficiency. And therefore, we thought it is not possible only to look from one perspective, from one angle, but we have to look on this complexity of elements which are important so for well-working judiciary. I would not only confine these principles to Eastern and Central Europe. I think the Central European experience, which we have done, and we have so many difficulties now, for example, in Poland, to somehow to come back to well-working system because so much harm has happened to the system. I think it's an important warning also for all Western democracies, that it is necessary to have a kind of critical review on all systems and to say, oh, we are safe here because we have other safeguards. But I think this review must be done before it is too late. So I think it was one of the functions, I think, of these principles to be a kind of little bit of warning sign, a little a model for self-reflection, with clear understanding that the systems are so different that we have always this problem, oh, there is another model which is working, but it's so difficult to describe and put it in. And of course, the example of English king is a good one, that it is so difficult to put such kind of models which have very long specific tradition into such kind of system. Yeah, but I think nevertheless, it finds this balance, and it's enough for judges, but also for lawmakers to have a critical look on their own legal systems. Thank you.
Thank you, Frédéric. Leah, do you want to add something?
Briefly, first I should mention that Carolyn Hammer, who's the associate of Tea Yaliashvili, was an observer in our project, and we really enjoyed very close cooperation with ODHR, and did Carolyn and I did a joint presentation at an international conference because we talked a lot about the central issues we were confronting together. One of the most important being freedom of expression. I mean, I very much appreciated Temur's comments because we spent a lot of time on that balance, and we were very intentional about this notion of moving beyond just the fact that the judge is a citizen and has constitutional rights, but that there can be situations there really is a duty to speak. And he's absolutely right on. That's a point where then there's legions of examples of where disciplinary processes have then, flashed back about that. Just to echo something Frédéric said, I mean, I came to this project from having worked extensively in Poland and worked a lot with Frédéric, although I've also had quite a bit of experience in other parts of Central and Eastern Europe and in Central Asia. And so it was interesting. I'm an expert on lawyers' ethics. I hadn't thought so much about judicial independence in the United States, quite frankly. This project has been very helpful. And I can't say I share enormous optimism about our moment in time. Things in the United States do not. I mean, these standards I think about every day in the context of the United States now. And although they, of course, are European standards, but I share Temur's view that there are multiple threats on multiple fronts, both in established European countries and in countries like the United States. And that's why it's a very important moment for them. To echo something Frédéric said, How Democracies Die, a book by Stephen Levitsky and Daniel Zablotsky, Harvard professors, is something that I found very interesting. Their concept is the guardrails of democracy. And they go historically in the guardrails that used to keep the United States specifically, from just moving off the edge to extreme things. Frédéric's son, when the Poles, the peace government, when they were doing various things, would add new legislative provisions harassing judges and saying, well, the Germans do this, the Danes do that, it must be fine. That's what Kim Shepley called the Frankensteinization of judicial reform. I've forgotten the specifics, but Frédéric's son interviewed a German official about something that the Poles were saying, well, the Germans do it. And so or have that legal provision. And when his son asked the question, he asked this person, well, would it be possible to do that in Germany? And the person said, I suppose so, but we wouldn't. And what we are seeing every day in the United States for a while now are things that people just never thought anyone would think of doing. And that's where the culture of judicial independence is important, where the guardrails of democracy are important. We very carefully take a position that does not say independent judicial councils are the answer. One of our excellent members, David Kosar, has written an excellent Cambridge University book comparing Czech Republic and Slovakia, where he very much takes the position that the model in Czech Republic with Ministry of Justice were okay. And he comes down in the end to public opinion, public perception, and judicial virtue matter. What matters is the choices individuals make and the degree of public support and public trust in the judiciary.
Thank you, Leah. I'm going to ask now. We have 3 questions from the participants. One is directly to Professor Frédéric Zoll. One area where disciplinary matters, both procedure and substantive law, is highly developed in international administrative law. Do you explore that avenue in your work from Mons Scopus? And this is from Kirian Bradley. So perhaps Frédéric?
We are looking for very different models, and it is somehow equal here in our system. But the main incentive was that in many European systems, the basis for judicial responsibility is very vague, and of course. It is so. It is very difficult to create sufficiently flexible system, which would say not the dignity is not the dignity or the violation of dignity should be enough because we have judges now. We have due process, so the guarantee is in the system itself, and we have to be flexible because there are so many conducts which could violate the dignity of the court, and therefore the general clause is necessary to be there. But probably certain certainty of description of disciplinary delicts is necessary, and this is due to the fact that this vague system, mostly if the another elements of the model are also under threat, is a path to endanger really the independence and to endanger the standing of judges. And therefore we were trying to say certain standards of criminal law must be observed. So nullum crimen sine lege, of course, with specific adaptation to the system, must be somehow also observed in disciplinary procedures. Even, and probably the risk of it is a little bit less, even that certain behaviors would be unpunished, even we have a general feeling it should be punished, it should be sanctioned. Sometimes, of course, we can describe the rules a little bit more, probably more general than in criminal law would require, but a certain tendency to go into this direction, I think, is very important.
Thank you, Frédéric. We do have 2 other questions. Perhaps I'm going to express them at the same time. One is from Alexandra Janowska. What safeguards might exist to transform the procedure from bringing a judge to disciplinary responsibility into a deep revision of his or her judicial decision? So that's the first one. And second one is in relation to the limit of transparency. What are the limits of transparency in judge nomination, promotion, mobility of judges for the procedures? While transparency is essential for public trust, some evidence suggests that excessive openness may lead to behind-the-scenes negotiation, potentially undermining the intended goals. So how can transparency be promoted in a way that prevents such counterproductive effects? So one in relation to the link between the procedure and the revision of the decision made by the judge, and the other one to the limit of transparency.
I'll talk about transparency, and I'll let Frederick talk about the other question. When we had the webinar about appointment, when Professor Turin was speaking, I think that that does become a complex issue. We discussed a lot about the fact that some of the screening of judicial candidates, that review, I think appropriately is done in a closed session. People talked about the notion that there are, when you're talking about the appointment process, the review process, particularly the appointment process, that although in a career judiciary, of course, that happens very early. So I guess you're talking about the promotion process, but that can cause good candidates not even to want to apply if this is going to go through. And I think that does become a difficult question. I think with regard to, again, what we're focused on, and Frederick and I particularly worked on in these sessions, when you're talking about ethical conduct standards and you're talking about discipline, we do talk about the importance of the screening mechanism. I do think a number of countries don't have perhaps explicit ways to screen out frivolous complaints and complaints that are politically motivated because there's really no evidence for them. And I think, and we don't talk specifically about the degree of what is not made public there. And the fact that if, for example, when there's a complaint, that the judge normally is notified, but that there's two situations specifically in the standards where the judge wouldn't be notified. One, we're afraid that evidence would be destroyed. And on the flip side, that it's just, it's possible there's not even going to be a statement of a claim. And we do then talk about, for the things that are screened out, that those would not be made public with judges' names. I mean, there's a very explicit discussion of that. When you move over to actually a charge being made, I have trouble seeing arguments against transparency. I think what you found in Poland is that the transparent part of the judicial system was the part the judges wanted. They wanted the open hearings. They wanted the visibility of what was going on because that was one of their protections. So again, on the appointment side, the review side, the promotion side, I do think that is an important area for talking about parts of the discussions that should be confidential. But on the discipline side, for me, it's a very bright line between the preliminary investigation before a complaint is filed, where there are places, where things in fact should be, and at some point certain judges' names should never be public. But once it's flipped over to a complaint, kind of all transparency. There.
Thank you, Leah. Frederick, could you very briefly answer the other question? Because I would like to...
If I understood it correctly, of course, in our standards is that there is generally no liability no responsibility for a judgment, unless it is this violation of law is done in bad faith. So of course we have a certain open clause. So under certain circumstances, the judge could carry responsibility for the content of the judgment, but it must be stressed that there is absolutely an exception, and generally it is not a disciplinary procedure which serves to avoid or to circumvent judicial review or to other elements of justice, and the judge must feel himself or herself comfortable in rendered judgment. And of course, there is a certain threshold, certain limit to it in absolutely exceptionally cases where the violation is done intentionally. Probably this bad faith term of our standards covers also gross negligence, but we want to stress that it must be absolutely exceptional.
Thank you very much, Frederick. And now I would like to have a last reaction to all what was said by our three participants who reacted to ELITE standards. Temur, would you start with this conclusion for you?
Thank you
and
very
you
much,
wanted to add something. Yeah, please.
Yes, I will lower my hand. I agree with the speakers about the need to be cautious, and from the international standards point of view, there's no solution, and it definitely should be merit-based and free from discrimination. Then transparency, you need to approach, there are different ways to approach, and the balances that should be struck. But just to I would only be cautious in making this causal link between openness, transparency, and behind-the-scenes negotiations, which is the question that was said alleged in the question. I would just say that negotiations behind the scenes play a role where the system fails to be transparent and merit-based and fair. So once the system manages to fix it, I would say it's not the transparency, it's where transparency didn't manage to reach. And transparency doesn't always mean publicity. It probably would, transparency could be within the system to ensure its justice. But otherwise, I really enjoyed today's event, and I appreciate a lot the opportunity to speak here. Good luck. I think this comprehensive document, at least in our work on defending the justice systems, the independence, is quite a valuable contribution. Thank you very much.
Thank you very much for your answer and for this last word. And Thea?
Yeah, really, very briefly in the interest of time, because I mean, a lot has been already said, but I mean, as we were discussing about the transparency, right? So, I mean, I think that the most important is to keeping the balance, right? And should focus on clear, merit-based criteria and publicly available procedural rules and reasoned decisions, of course, and while ensuring confidentiality wherever necessary. But also there has been, of course, I mean, part about the freedom of expression, I mean, which also, I mean, it's like a golden balance in between how you exercise those rights within this particularly challenging and important, you know, merit-based, I mean, exercise of the duties and the I mean, tasks over there. So, but last but not least, I mean, it was a greatest pleasure. I truly hope, you know, to continue these extensive, I mean, discussions on these very pressing issues. And at ODIHR, we stand ready, of course, I mean, to further contribute, I mean, to the rule of law and justice and democratic principles. Thank you.
Thank you very much, Thea, too. Georg, the last word from a judge.
Thank you. I enjoyed being on that panel immensely. Thank you to everybody. And if that document assists in creating or improving an awareness of the issues we just discussed, an awareness of the importance of judicial independence, that would be great. That is a goal we all share. And I wish the document and all persons involved with that good luck. Thank you.
Thank you very much. So I only have 1 minute to thank everybody. So to say thank you first to the co-reporter who made such a great job. And of course to our 3 participants who reacted and who brought so interesting ideas, opinion, remarks, and reactions. I think that it was said expression of this core principle needs to be emphasized, and this is what you did by your reaction. Thank you also to all participants and to the 3 persons who asked such interesting question. And I have to say that the next webinar will be on defining artificial intelligence system under the AI European Act, and that will be on 19th February, same time. And the discussion will be on the proposal made by Eli, which is on the basis of 3 factors, but I won't say anything more. I won't leave the suspense on the 3 factors to attract you to this next webinar on 19th February. So Again, thank you very much from ELI, from all the members of ELI, and see you soon. Bye.